Good morning, everybody, and thank you for joining us on our relaunched in-house legal webinar series. My name's Laura Farrington. I'm the Head of Client Services at Field Seymour Parks. I'm just going to do a brief intro with a few admin points, and then I'll hand over to Tom Maple, who's head of our dispute resolution team, and Bill Dixon, who's a partner in our dispute resolution team also. Today, the topic will be on legal privilege. They'll cover various points, and Tom will introduce that in a second. First up, if there's any technical issues, please bear with us. This webinar is being recorded, so you will be able to watch again if there's anything that you miss. You're also able to forward that on to colleagues to view. We will be taking questions throughout the webinar, which I'll collate at the end and put to Tom and Bill to answer. Finally, there will be a feedback survey at the end of the webinar, which we'd really love you to complete. For every feedback survey completed, we'll be donating to a local Reading homeless charity called Launchpad. We hope you enjoy this. Tom, over to you.
Okay, I think you need to kick on one slide. Okay, so hi, obviously I'm Tom, as Laura said. So by way of brief background, legal professional privilege is a common law legal right which was developed around 200 years ago. As I'm sure you all know, it exists in order to assist with the administration of justice by allowing clients to be open and frank with their lawyers, safe in the knowledge that the lawyer excuse me, may then withhold from scrutiny any of the communications which relate to either the seeking or giving of legal advice or the process of litigation or other forms of contentious investigations. Legal professional privilege, and I may abbreviate that to LPP, and legal advice privilege to LAP. LPP is a right which is unique to the clients of lawyers. Therefore, whilst professionals such as accountants or other professionals may give confidential advice, that advice won't be privileged and hence may be compelled for disclosure at a later date. I do recognise that there is one or two statutory exceptions which allow professionals to give privileged advice, but as it is the exception, I don't propose going over those today. It's worth noting that whilst lawyers regularly record that certain documents are privileged, the label of itself doesn't make the document privileged, i.e. it's not determinative. The fact that you mark something privileged does not mean it is. Of course, that aside, I would recommend that all privileged documents be marked strictly private and confidential and subject to privilege, not least to evidence at a later date if the issue arises that you felt the document was privileged. One further point to note at the outset is that at an initial stage, one way to avoid creating or circulating communications which may not be privileged is to discuss matters with relevant people within your organisation, on the telephone or in person, before you put matters in writing or before documents are circulated. So LPP comprises litigation privilege and legal advice privilege. I will focus on legal advice privilege, and then Bill will cover litigation privilege. Laura? Oh, sorry, I should have gone on a slide more. Next one, Laura. Thanks. So in terms of the relevant test, legal advice privilege applies to confidential communications passing between a lawyer and the client, which have come into existence for the dominant purpose of giving or seeking legal advice. Litigation doesn't have to be in contemplation, and it does not matter whether the communication is directly between the client and his legal advisor or is made through an intermediate agent of either. To be clear, it does not matter what the topic of the legal advice is. It could be the interpretation of a statute, how to draft a contract, advice on tax law. Broadly speaking, it is anything with a relevant legal context. A significant change that came into play in 2020 and the Jet 2 case you can see on the screen is that the law relating to LAP has aligned itself with the law relating to litigation privilege by the addition of a dominant purpose requirement, and more on that later. So there's 5 key areas that one must consider when considering the issue of legal advice privilege, namely who can give the privileged advice, who is the client, what amounts to legal advice, the dominant purpose test, and matters of dissemination. And I'll go over each of them now. As I've already mentioned, whilst there are some limited exceptions, it remains the case that only lawyers can benefit from legal advice privilege. So who is a lawyer? Everyone who is qualified as an English solicitor must have a practicing certificate. So for the vast majority of people, it's easy to determine who a lawyer is. The Supreme Court has recently confirmed that SILEX falls within the relevant requirements, and therefore legal executives can give privileged advice. As to foreign lawyers, trainees and paralegals, the key question is whether they are working under the supervision of a qualified lawyer, and if they are, then they too can give privileged legal advice. It's important to note, for what it's worth, that the lawyer's job title is irrelevant. The issue is whether they are exercising their professional skill as a lawyer at the time of the relevant communications. There's obviously a number of particular implications for in-house lawyers, not least the important question of whether what you are giving is legal advice and not business advice. However, in my view, the starting point is usually identifying who your client is within the business. This is not always straightforward, particularly in larger companies. The problem for in-house counsel stems from a case known as Three Rivers No. 5, which I'm sure some of you will be familiar with. The facts arose after the collapse of BCCI in the 1990s. Three Rivers provides a restrictive definition of who the internal client is. It's not a popular decision and has been distinguished in other common law jurisdictions, such as Singapore, Hong Kong, and Australia. However, and unfortunately for many of you, it remains good law in England and Wales. In practical terms, you cannot assume that your client is your whole employer. Rather, what you need to do is identify the narrow group of people who have been charged with seeking your legal advice, and then treat them and only them as your client. If that team expands or subtracts, then you should take your instructions from that reduced or enlarged group only. One problem I've seen arise is where someone who is not originally part of the client becomes involved in matters at a later stage. Care in those circumstances must be taken, since communications with them will not be privileged if they are not within the ambit of the client. Once you've identified who the client is, you may then want to work out who has the relevant information. Where you can readily obtain it from within the client, no issues arise. However, in a number of instances, the effect of the narrow definition of client means that it may well be that the steps which are required to seek or gather information will not be privileged. In these instances, it will be worthwhile taking steps to assess the issues and the relevant risks before documents are created or circulated, by, for example, discussing matters on the phone with those people who are central to the issues about which you are advising. The narrow approach taken in Three Rivers No. 5 creates an obvious inequality, that is, restricting legal advice privilege to communications passing between the lawyers and the client presents a problem for large or multinational corporations, because it is unlikely that the information on which legal advice is to be sought will be solely in the hands of the company board or those it appoints to seek or receive legal advice. Therefore, such entities will be in a less advantageous position than a smaller entity seeking similar advice. However, I can't give you an answer to that since the law is unchanged, and whilst it may be distinguished in the future, that is a practical problem that larger corporations will have to address. Laura, next one. So LAP can be asserted over various forms of communication. Communications has a wide definition and includes, amongst other things, letters, emails, a client's note of your advice, text messages or other forms of instantaneous messaging, oral communications such as voicemail messages, and contact details and client identity. Whether such documents are privileged or not depends on whether they are part of the necessary exchange of information, of which the object is the giving of legal advice. It's important to note that privilege does not apply to communications which were not created for the purpose of obtaining legal advice. Indeed, that is the very essence of the right. Emails and attachments should not be treated as a single communication. The email may well be privileged, but it does not therefore follow that the attachment will be as well. So you have to look at both documents. The recent Jet 2 case also made it clear that any draft of communications created before in-house lawyers were consulted or created without any involvement of in-house lawyers were not privileged, even if it was known that in due course legal advice would be taken on the draft, unless the client could show that those communications were specifically drafted for the dominant purpose of obtaining legal advice. For privilege to apply, the documents must be communicated to the lawyer. Generally speaking, there must be a continuum of communication. However, I should stress that a document does not become privileged simply by reason of the fact that it is communicated to the lawyers. So what then, using a common example, what then happens if a communication is sent to multiple parties? Some lawyers, some not. Does it lose privilege? In these circumstances, you have to apply the dominant purpose test and ask yourself whether the communication or document was brought into existence with the dominant purpose of giving or seeking legal advice. Privilege is not lost merely because non-lawyers are copied into the email. The question is, what was the dominant purpose? It goes without saying that whilst the dominant purpose test may be in your favour in relation to a particular email, that legal advisors and clients alike should be aware that circulating documents too widely may lead to subsequent challenges in litigation, for example. To protect from this eventuality, legal advisors and parties should exercise caution when circulating communications to mixed recipients. Laura? So in terms of, yep, I can go back. So in terms of the dominant purpose test, I'll briefly consider that now. But before doing so, I'd firstly like to note that legal advice is not confined to communications in which the lawyer is telling the client the law. For example, certain communications merely informing and updating one's client could attract privilege in the same way as communications advising a client do. For example, in a recent case, tables created by counsel detailing the current state of libel litigation around the world in order to keep its client appraised of ongoing libel litigation was held to be privileged. So what then amounts to a dominant purpose? Provided communications are directly related to the performance by the lawyer of their professional duty as legal advisor to their client, and the dominant purpose of the document was the giving or receiving of legal advice, then communications between the lawyer and their client will be privileged. In the case of an email sent to an external lawyer, the dominant purpose would be unlikely to arise. However, this issue may not be as clear-cut in the case of in-house lawyers, because, for example, in-house lawyers may often take part in general business discussions which do not involve any legal advice. Where in-house lawyers are clearly being asked by their client for legal advice, privilege is of course likely to attach. However, where the in-house lawyer is being consulted about a largely commercial issue, then you'll have to consider the dominant purpose test. In practical terms, if the dominant purpose of a communication is to seek commercial views, then the communication or that part of it expressing the lawyer's commercial views will not be privileged. Where an in-house counsel is performing a dual role, i.e. both commercial and legal, it would be worth considering whether to separate the advice out into two documents if the dominant purpose you're satisfied is clear, then that may not be necessary, but it is worth considering that issue at the very outset and consider it whether it is worth separating that advice out. Laura? So then in terms of dissemination, dissemination of confidential and privileged advice does not of itself amount to a waiver. However, if you disseminate it too widely, you increase the risk that it loses its confidentiality. So care is obviously required. As a matter of practical application, do not circulate privileged advice or privileged documents wider than is necessary. Further, when circulating advice, mark it strictly private and confidential and subject to privilege. If you distill your advice into digestible portions, the extracts remain privileged. However, I would again recommend that you mark those extracts privileged and confidential. One issue that we have advised on relatively recently is what happens if the advice is circulated at board meetings, that is, whether privilege is lost and how the meeting should be minuted. Discussion of legal advice and what to do with it at a board meeting is privileged. If the minutes reflect that advice or the discussion on that advice, that part of the minutes would be privileged as well. However, as a matter of practicality and as a general rule of thumb, I take the view that it makes sense to make two sets of minutes, not least to embolden the argument that the relevant discussion was privileged. Not only does that assist to keep the privileged conversation out of the board minutes, but it may be that anyone having sight of those minutes at a later date, for example, your opponent in litigation, may not realise there is a privileged discussion at all. Again, a word of warning, whilst privilege may not be lost by discussing it at a board meeting, it is important to cut down email traffic relating to the advice or the discussion at the board meeting, since if those emails introduce new facts, then you may have a Three Rivers number 5 problem if the person communicating those new facts was not part of your internal client. So if the matter does not end at a board meeting, you should continue to make sure that the people giving you instructions remain those who are within your client. And that is where I'll pause on legal advice privilege, and I'll hand over to Bill on litigation matters.
Thank you, Tom. So as Tom explained at the outset, there are two main types of legal privilege. There is legal advice privilege, which Tom has already discussed. I'm now going to deal with the alternative type, which is litigation privilege. Inevitably, you can have an overlap between both types of privilege. One document might be covered by both. But in a nutshell, if you have documents covered by litigation privilege, which is where you're in a situation where the documents you're creating are in furtherance of litigation in some way, the main difference is that potentially, at least, this privilege can be available to non-lawyers. You don't necessarily have to be a lawyer to make use of litigation privilege. Now, what I would like to do is just highlight 7 aspects of litigation privilege, just to flesh out 1 or 2 of the potential issues which can arise when you're considering a claim to litigation privilege. And the first issue I want to touch on is the fundamental requirement of litigation privilege is that you must have litigation. By litigation, that can cover civil proceedings, it can cover criminal proceedings, it can also cover regulatory proceedings, arbitration. However, what is needed is some sort of adversarial element. So if you had a purely fact-based inquiry of some sort, litigation privilege would be unlikely to apply there. You then need the proceedings to either be in existence or they have to be in contemplation. And the phrase you sometimes hear in this context is that proceedings have to be in reasonable contemplation. What exactly does this mean? I don't think it will be enough to simply have proceedings as a mere possibility. There has to be a reasonable prospect that civil proceedings could be on the way, but there is certainly no strict test where, for example, you have to say the proceedings are 51% likely or above. Provided there is a reasonable prospect that proceedings could arise, you should be able to rely on litigation privilege. Now, in the case of criminal proceedings, for a while, there was an issue caused by the case of ENRC against the SFO, because at first instance, a judge held in the context of criminal proceedings that there was a distinction between a criminal investigation by the authorities on the one hand and an actual criminal prosecution on the other. And what the first instance judge held in that case was that if you were only anticipating an investigation, that was not sufficient. You actually had to have got further into the process and be anticipating a prosecution. Now, that was a problem on the facts of that case, because this was a company that had carried out a number of investigations over corruption allegations relating to an overseas subsidiary. There had been lawyers involved, forensic accountants had been engaged, there'd been a large number of reports, witness statements, but at first instance, at least, the judge was saying that all this material was disclosable because what was being anticipated was a criminal investigation, not a criminal prosecution. Now, that was quite a coach and horses potentially through the concept of litigation privilege, but the case was subsequently set aside on appeal. Third issue, as Tom mentioned, with legal advice privilege, there is a dominant purpose test for litigation privilege. Many of you may remember the classic case in this area, war against the British Railways Board. Basically what happened is there was a rail accident, someone was killed, and the British Railways Board commissioned a report into the accident. Now, although it certainly was the case that this report was commissioned anticipating civil claims and potentially even a criminal investigation or prosecution, the court decided in that case that litigation was not the only purpose. The other purpose that this report was produced for was because it was part of British Rail's ordinary safety protocols. And eventually what was concluded was that although litigation was a purpose in producing this report, it was not the dominant purpose, and therefore the report was disclosable. Now, at this point, it may be worth just pausing and flagging up what, in my experience, are some of the common situations where you can get into difficulties in this area. Number one, if you have a case which is in the public domain, let's assume your name is perhaps Johnny Depp, and you decide that you want to engage with PR advisors, inevitably there would be a very serious risk that those communications would not be covered by litigation privilege because they would not cover, they would not satisfy the dominant purpose test. So that's potential problem area number one. Potential problem area number two is where you have a corporate takeover. Obviously, the buyer of a company is likely to want to understand whether the target company has existing litigation on foot and if it does, they will want to get a handle on what the risks are in that in that litigation. However, if you are communicating with lawyers acting for a buyer, the dominant purpose is not the furtherance of litigation, and again, you're likely to get into difficulties. And then I think the third classic area where you quite often get into difficulties if you're not careful is when your auditors come asking about a particular piece of litigation. Now, it's entirely understandable that your auditors have to understand and get a handle on what potential liabilities a company faces. Nevertheless, great care has to be taken in communicating with the auditors, and you might have to take various steps. For example, with regard to auditors, you may need to carefully define in advance that privilege is only being waived for a very limited purpose. In the case of a corporate acquisition, what I've typically seen happen is you invite the buyer's solicitors to come round, read privileged reports and take notes on them, but not actually take away copies. So in practice, they are some of the areas that can fall foul of the dominant purpose test. Now, point number 4, for many years, there was a debate over how wide is the concept of litigation privilege. So are we saying that if you're generating material which in a very broad sense relates to and is in furtherance of the litigation, that that's sufficient to give you protection? Or are we applying a much narrower test where you're focusing on delivering advice in the context of litigation, or perhaps obtaining or reviewing evidence? And this was something that came up in a case called WH Holding and E20 Stadium, where in common with many of the recent cases which have tended to take quite a tough approach to privilege, the conclusion the court came to was that the appropriate test is the narrow test, and documents are only protected if they are to do with delivering litigation advice or with the gathering or reviewing or discussing of evidence. And the WH Holding case involved West Ham and a dispute over the allocation of stadium seats. And before litigation had commenced, there was a situation where the board of one of the parties was considering a set of commercial proposals, and emails were being generated both between board members and stakeholders. Now, you could certainly say that in a very broad sense, these emails were generated in a context of litigation. They had no other purpose. However, the court said they weren't really to do with delivering advice or gathering in or reviewing evidence, and therefore privilege was lost. Now, it probably is worth noting that on the particular facts of WH Holding, you did not have commercial proposals which were entangled in with references or comments on litigation advice or the strength of the evidence. It was possible to disentangle the commercial proposal discussion from other aspects of the case. Had there been more of an entanglement in that case, I think the decision might have been different. So, as I said at the outset, litigation privilege can extend both to lawyers and non-lawyers. So typically, if a personal client or if employees or managers of a corporate client are communicating with third parties, for example, discussing issues with potential witnesses or liaising over getting in documents from third parties. Those communications should be covered by litigation privilege if all the other requirements are met. Now, in the light of some of the more restrictive cases which have come around recently, such as WH Holding, I do think a distinction has to be drawn between communications between a non-lawyer and third parties and internal communications. I think if you have communications within an organization, not with third parties, and which don't involve lawyers, I think in the light of cases like WH Holding, such communications are likely to get scrutinized quite carefully, and I think there is a serious risk that privilege could be lost there. Point number 6, the documents must be confidential. So if you start disclosing your privileged documents to too many people, if they appear in the public domain, privilege could be lost. And if we could move to the next slide, please. The 7th and final point I want to make about litigation privilege is that expert reports have special rules over privilege. So under normal circumstances, if a party instructs an expert in litigation, those instructions are privileged. However, because the court has an interest in making sure that experts stay relatively objective and do not simply become advocates for one of the parties to a dispute, and because it's important that the expert's opinion is understood in the context of the information and the instructions they were given, as I say, there are some special rules around expert reports. So for example, CPR 3510 makes it clear that privilege does not apply, strictly speaking, to instructions to a court expert. It is not the normal practice to order the disclosure of those instructions unless there is a reasonable concern that perhaps the expert was given misleading or inappropriate material. Nevertheless, in a formal sense, privilege disappears. And there have also been cases such as a 2013 Galliford Try case, where the courts have said that if there is a suspicion of expert shopping, in other words, if you have a party who's going to expert number 1, trying to see if they come up with the answer they want. If they don't get the answer they want, they move on to expert number 2 or expert number 3 until they finally find someone who backs up the opinion they want. If there is a suspicion that that is happening, what the courts have made clear is that before they give permission for the final expert report to be used, they may apply as a precondition an order for disclosure of the earlier expert reports. Now, on the facts of Galliford Try, it didn't actually happen, but there is a risk that it could happen. So they are the 7 points on litigation privilege that I wanted to tease out. Another common sense comment I also wanted to make is documents which already exist and which are not privileged in any sense do not become privileged simply because they are disclosed in a litigation context. So the classic trap that you can fall into is you are approaching a witness, you want to see if they've got evidence that might be helpful to your case. You can exchange emails, you can have telephone discussions with this witness. this is in furtherance of litigation, and therefore those communications are going to be protected by privilege. Now, if the witness says during the conversation or in an email, oh, by the way, I've got some emails that I think you might be interested in seeing, and you then say, great, send in the emails. If those emails were not privileged already, they don't acquire privilege status just because of the litigation context in which you acquired them. And then the moment the emails are transferred from the witness to you, they then automatically are in your custody and power, and they will fall for disclosure, whether those documents are helpful or not. Now, I'm conscious that some of the rules I've touched on here are quite complex. What do you do if you're in a bit of a grey area? So you think you've got a reasonable argument for privilege, but you're not entirely sure whether the judge will buy it. Maybe you think, it's a 30%, 35% argument based on the case law you've seen, but you're not entirely sure. What should you do in that situation? And it's probably worth remembering, being somewhat cynical, that in practice, most of these cases where disputes over privilege have gone all the way to the Court of Appeal have quite often had at their heart a damaging document, which one side or the other is looking for an excuse to keep back because they realise it could very seriously harm their case. Now, my own personal approach to this dilemma is that I do think it is legitimate for a party to assert an arguable claim to privilege if you think you have a respectable argument, and certainly the law isn't crystal clear. Why shouldn't you be able to run that argument? Why should you have to disclose a document that damages your case? However, if you do choose to run an argument which might be slightly questionable, I think what you probably have to do is fairly disclose the document in your list of documents in a way where you make absolutely clear what your claim to privilege is. And that way, if your opponent understands the basis for your claim to privilege, they are able to choose to challenge it if they wish to do so, and you can't be criticised for withholding documents. If we could move to the next slide, please. So that is all I wanted to say on litigation privilege. Obviously, in preparing this talk, we were conscious of the constraints of time. There are a number of other related issues which we haven't gone into. And before I conclude, I just wanted to very briefly touch on the issues that we haven't had time to cover. Obviously, if you have some questions in this area, we might be able to take this as part of our questions, or we might be able to answer emails, or even alternatively, if there is overwhelming public demand for one of these issues, you may even tempt Tom and I back to do another webinar. But just looking at some of the related issues that unfortunately we haven't had time to cover in detail, and they can be quite complicated concepts. First of all, confidentiality. Just because a document is covered by a contractual confidentiality restriction, that is not the same as privilege, and it does not necessarily give you a basis for withholding the document in the context of the court proceedings. Now, it may give you a reason to apply some fairly strict terms over the basis of the disclosure, but it is not, like privilege, a basis for completely withholding a document. One particular type of privilege, which has its own rules, is without prejudice privilege, communications where you are trying to settle a case. And of course, going back to that WH Holdings West Ham case, if things had got beyond an internal discussion of commercial proposals and had progressed to those commercial proposals being delivered and discussed with the other side, then of course, without prejudice privilege could have been triggered. Common interest privilege is where you have a number of parties who are on the same side. Say you have a number of co-defendants who decide that they will cooperate together and share information. In certain circumstances, common interest privilege can apply there. And then the final thing to always remember over privilege is that you can waive it. So if in correspondence or a submission in court or a witness statement, you airily start referring to your legal advice or counsel's advice or some such phrase, you may find that you actually waive privilege, not only in the immediate document you were referring to, but in the entire subset of documents that fairly relate to that issue. So you do have to be quite careful over waiver of privilege. So thank you for your time and for staying with us so far. What I will now do is hand over to Laura, who will be able to tell us whether we've had any questions or not. Thank you.
Thanks so much for that, both of you. That was really informative. We have had a couple of questions come through, so I'll kick off. The first one is, why do you think so many cases have tended to cut down the scope of privilege?
Shall I take
yes,
that?
yes, please do.
I mean, I certainly think there has been a trend in the last 5 years where I have encountered a number of decisions I found quite surprising. As you can see by my grey hair, I've been around doing litigation for many decades. I would never have predicted some of the cases that have emerged in the last 5 years in terms of just how far they've gone in reducing the scope of privilege. Why is it happening? I guess there are two possible thoughts as to what might be happening here. I mentioned earlier on that quite often at the heart of a privilege dispute is a document that one party or the other is trying to keep back because it damages their case. And I suppose human nature being what it is, there may be a natural tendency on the part of judges to want to see fuller disclosure and not have things being held back. The other thing that might also be having an impact is I think the average judge is a barrister rather than a solicitor, and because of that they perhaps don't have the same appreciation of the value which solicitors certainly appreciate of being able to generate documents under the cloak of privilege and the important safeguard that represents to the efficient functioning of the litigation system.
Great, thank you. And then the final question that we've got in is, can a subsidiary share advice given to it with its parent?
Well, I guess I'll have to take that then. So all things equal, it can without losing privilege, provided subsidiary or parent, as the case may be, does it under the relevant conditions of confidentiality, i.e. making it clear that before it's shared that it's subject to privilege, they'll agree to keep it confidential, and so on and so forth. Of course, you couldn't then assert confidence against that parent to the extent any issues arise as between the two of them at a later date. But that's the short answer. One issue that might arise is that if the foreign company, if the parent company is based overseas, then you may want to take local advice as to whether that parent is subject to different rules, and if so, whether privilege may apply in that jurisdiction. And one point that did come up through researching this webinar was that the EU Commission, when investigating competition inquiries, don't recognise legal professional privilege by in-house counsel. So that would be something to factor in if applicable, and again to take local legal advice on. And one point I thought about whilst Bill was talking about the sort of criminal side of things is that, of course, one obvious exception to legal advice privilege rules is where the legal advice effectively was part of a crime or a fraud, and there is a crime fraud exception to legal advice privilege, and where that applies, clearly you can't assert privilege over that advice. But that's the short answer to your subsidiary question, Laura.
Great,
I mean,
thank you.
I suppose in practice, one piece of advice that might be worth passing on is obviously if you have a holding company in the UK and an overseas subsidiary, as well as the issue of foreign law, privilege, and all the rest of it, there's also the question of who actually has possession of the documents. So if you're sitting in the UK and you are facing litigation or some sort of investigation which has global implications, if you are stupid enough to say to your overseas subsidiary, send us all the files, guys, we want to see all the emails so that we can properly investigate the case, what you may find is that you have inadvertently brought into your possession documents that arguably were in the possession of a non-party to the litigation, so you could have fallen into an elephant trap. So this isn't really a privilege issue, it's a more practical question of just think very carefully before you ask people to send you stuff, because once you've got it, you're stuck. You can't send it out again, because on disclosure, you've got to say which documents did you once have that were relevant to the litigation and where have they now gone to. So always be very, very careful before stuff gets sent to your head office.
Great, thank you both. Just on the final point, Bill and Tom's email addresses are there if you want to contact them directly. As I mentioned earlier, upon closing the webinar, a feedback survey will pop up and we will be making donations to Launchpad, a local Reading homeless charity, for everyone completed. Thank you very much, and we hope to see you again for the next webinar. Have a good day.
Thanks.